a felony of the second degree, it is ordered that the defendant shall serve a term of 2 years in prison on that count.
How did you her? I don't know what you mean. Where did you
I don't know. I just started fighting with my life. I was so scared.
He spoke in cold detail of how, with his bare hands, he a defenseless 5-year-old girl.
Eddie and Rachel Schoaf carried out that plan. Together they and Skylar.
Taylor Smith, a teenager from Washington, was sentenced to 2 days in jail and 38 days on a work crew after pleading guilty to reckless endangerment. This was related to an incident where Taylor pushed her friend Jordan Holderson.
3, 2.
Well, she's saying no.
Ready?
On August 7th, 2018, at Moulton Falls Regional Park, an incident occurred on a 60-foot bridge. The event was recorded on a cell phone and went viral online. Taylor was fined $300 and ordered to avoid contact with Jordan for 2 years. Jordan sustained 6 broken ribs and punctured lungs from the fall. During the trial, Clark County District Court Judge Darvin Zimmerman highlighted the seriousness of Hogg's injuries before announcing Taylor's sentence. "I think you need to do some jail time," Zimmerman said. Before sentencing, the judge listened to the victim, her mother, and the defendant. Jordan was too emotional to speak and had a victim's advocate read her statement. "This nightmare started for me when I was falling through the air and I was really terrified. When I was being pulled from the water, I thought I was going to die because I couldn't breathe and I was watching my body change color by the second." Her mother, Janelle Holderson, told the judge she believed Taylor acted intentionally and should serve as many days in jail as her daughter spent in the hospital, which was 3 days. Taylor initially pleaded not guilty in September, but changed her plea last month after being offered a deal by prosecutors. They recommended she receive no jail time and instead serve 60 days of home confinement, 30 days of service with a work crew, and 30 days of community service. Taylor apologized to the victim in court, saying she had grown as a person and learned to think before acting. "I'd like to sincerely apologize to Jordan Holderson and her family and friends for the pain and humiliation I caused by my mindless actions last summer," Taylor said tearfully. Although not a life sentence, Taylor's actions were extremely dangerous and could have, under different circumstances, cost Jordan her life. She is fortunate that Jordan survived the 60-foot fall into the water, which is generally fatal for most people. In 2013, Conrad Schaefer, along with 3 friends, began a reign of terror in Osceola County, Florida. They randomly opened fire on innocent people, resulting in the deaths of 2 individuals. One of the victims was David Guerrero, who was on his way to catch a bus to work. They killed David without reason, simply for cruel amusement. Their violence continued as they forcibly entered the home of 22-year-old Eric Rupnerine, who was just starting his life, and killed him as well. For 2 weeks, the community lived in fear, unaware of who was behind these random attacks and who might be targeted next. Eventually, Conrad was identified as a suspect and taken into custody. He later confessed and, as part of a plea deal, pleaded guilty to 2 charges of murder.
Investigators say Conrad Schaefer was only 15 years old when he and a group of his friends shot up more than a dozen houses in Osceola County. They say he also killed 2 men before being arrested and charged with first-degree.
It's hard to imagine being so young and making a decision that ruins your life forever, but that's what Conrad did. He was ultimately sentenced to 2 life terms in prison, with the possibility of a review of his case in 25 years. He hung his head low upon receiving his sentence. 3 years after the tragic events, he remains behind bars and may very well stay there for the rest of his life. Tony Farmer was Garfield Heights, Ohio's highly sought-after high school basketball player. Although he was not sentenced to life, he was considered dangerous and received a 3-year prison sentence.
The defendant shall serve a term of 3 years, which is the minimum on count 1 of that. As to count 2 in that case, felonious assault, a felony of the second degree, it is ordered that the defendant shall serve a term of 2 years in prison on that count.
In April 2012, Tony Farmer was convicted of kidnapping and assaulting his ex-girlfriend Andrea Lane, as well as robbery and intimidation, all coming from an incident that occurred in the lobby and parking lot of Andrea's apartment complex. The event was captured on videotape, and Tony also sent threatening text messages to Andrea. The judge stated she would review the sentence after 180 days. Tony, a 6'6" forward, had been ranked among the top 100 prospects in the class of 2013 for most of his high school career. Despite recently falling out of the rankings, he was still being recruited by schools such as Xavier, Dayton, Ohio State, Michigan State, Iowa, West Virginia, and Illinois during last year's high school season. Tony's trial was widely reported in the news, polarizing opinions nationwide. While some believed he deserved the harshest punishment, others, including the victim, his ex-girlfriend, disagreed. During the trial, a delegation of staff and students from Garfield Heights came to court to defend their fallen hero. In August 2012, Judge Pamela Barker found Tony Farmer guilty of his crimes and sentenced him to 3 years in prison. In 2015, Ashley Ann Rose Martinson became the subject of international headlines for a crime that defies belief. The day after her birthday, she tragically ended the lives of her own mother and stepfather. It was a chilling revelation that captured the world's attention. Martinson later admitted guilt to 2 counts of second-degree intentional homicide. As a result, she received a daunting 23-year prison sentence that would forever reshape her life. But rewind a bit, and you'll find a seemingly ordinary life. Martinson lived under one roof with her mother, stepfather, 2 stepsisters, and a half-sister before that dark day. According to her younger siblings, Martinson was allegedly verbally abused by her stepfather, Thomas Tony Ayers, leading up to his murder. Ayers had a history of verbal and physical abuse towards his wife and biological daughters. Experts believe that Ashley Ann Rose Martinson had post-traumatic stress disorder and depression. It's crucial to note that her stepfather had a criminal history, including convictions for kidnapping, sexual assault, and domestic abuse, among other offenses. Despite being legally barred from possessing firearms, he still had a collection of loaded guns readily available in the house. It all started when Ashley Ann Rose Martinson's mother and stepfather discovered her secret relationship with a 22-year-old man named Ryan Sisko. Words were exchanged, and the situation escalated to the point where her parents sent messages threatening legal action against Sisko. The tension was intense. That night, Martinson wrote a disturbing message on her social media expressing her desire to kill her stepfather. This is what she wrote. "He's going to kill her if she doesn't leave soon. I want to kill him so bad, take one of his guns and blow his brains out." The following day, Martinson witnessed her stepfather beating her mother, and in a fit of rage, she shot and killed him with a shotgun. When her mother came to investigate the gunshots, Martinson killed her with a knife. After the killings, Martinson locked her younger siblings in a closet with food. One of her siblings saw Thomas's body and didn't believe her when she denied killing him.
How did you her? I don't know what you mean. Where did you?
I don't know. I just started fighting with my life. I was so scared.
Martinson's tale took a turn when her younger sibling's police statement clashed with hers. She later claimed the gun was intended for a suicide attempt, but Thomas Ayers interrupted her. Martinson and Sisko were captured in Indiana after her eldest stepsister alerted the police. Next, at the Niagara County Courthouse for the arraignment of John Freeman, convicted of killing a girl he was babysitting. Authorities say Freeman choked Isabella Tennant at her great-grandparents' home, where she was spending the night while her mother was at work. Freeman, a neighbor of the homeowners, was left in charge of Isabella when they went to bed. He reportedly appeared calm as he explained the details of the murder to the police.
He spoke in cold detail of how, with his bare hands, he a defenseless 5-year-old girl.
Facing life imprisonment, all he could do was beg for forgiveness.
I'm just sorry.
He was sentenced to 22 years to life in prison. This is Rachel Schauf and Sheila Eddy, who are both in court today for the murder of their friend.
Scheme was to hide on their bodies and to attack Skylar at an agreed-upon moment.
In Star City, West Virginia, Rachel Schauf and Sheila Eddy were friends with Skylar Neese. Reportedly, Schauf and Eddy decided they didn't like Neese anymore, so they planned to kill her.
Eddy and Rachel Schauf carried out that plan. Together they and Schuyler.
After Rachel Schoaf's confession, both teens were arrested. Schoaf agreed to plead guilty to second-degree murder in exchange for her cooperation in the case.
I'm so sorry. I don't know if there's a proper way to make this apology because there are not even words to describe the guilt and remorse that I feel each day for what I've done. I hurt the Neese family and those who love Schuyler. I hurt my parents and shamed my family. May God bring eternal peace to Schuyler and the entire Neese family.
After securing a plea deal, the judge now hands down Rachel Schoaf's sentence.
Rachel Schoaf, it is the sentence of the court that you be imprisoned in the West Virginia State Penitentiary for a period of 30 years.
Sheila Eddy, who did not initially confess, was later charged with first-degree murder. Facing overwhelming evidence, she eventually pleaded guilty and was sentenced.
It is the sentence of the court that you be imprisoned in the West Virginia State Penitentiary for the rest of your natural life. That sentence is technically with mercy, which makes you eligible for parole after you have served 15 years.
In 2015, Jamie Melray and Charles Fisher thought they were about to pull off a smooth cannabis exchange in the heart of Omaha, Nebraska. Well, not so much. The moment they set foot in Miller Park, they got a surprise that no one saw coming. 3 boys jumped on them, with Jamie Melray taking fatal bullets to his head and neck, while Charles miraculously got away with just a shoulder wound. But here's the kicker. This wasn't a random ambush by just any boys. We're talking about Gerald Milton, his sibling, and another accomplice. Their master plan was to swipe some goods from the dealers and walk off with an easy payday. Fast forward, and Gerald pulls a vanishing act right after this horror show. The boy is apprehended in Minneapolis, miles away from the crime scene, and let's not forget, there was a staggering $25,000 reward for any information leading to his capture. Gerald's dad said his boy might have been there, but he didn't pull the trigger. Young Gerald pleads not guilty when his court date arrives, while his older brother Jamar isn't so lucky. Jamar ends up with a first-degree murder conviction and faces 58 to 82 years in prison, with his earliest parole option coming after 34 years. But that's not the end of the story. Gerald has also been charged with rape in South Dakota. His record shows a history of juvenile system failures and probation violations from 2015. Despite numerous interventions, including probation, curfews, halfway homes, and even time at the famed Boys Town, he keeps slipping through the cracks. In late 2019, he had a chance to leave for his mother's house in South Dakota, but he landed back in jail soon after. A court directive stated that Gerald Milton would be sent to a CUNY YRTC program to finish his probation, but that's not happening anytime soon. The latest reports indicate that Gerald Milton is cooling his heels in a South Dakota jail, done with playing games in the juvenile arena. Now, he's graduated to adult prison. In 2005, Kristen Avery Pittman faced the harsh gavel of justice, convicted for the murder of her grandparents, Joe and Joy Pittman. This wasn't some spur-of-the-moment crime. It happened in 2001 when Kristen was just a kid. At that young age, Kristen had already run away from home twice, struggled with suicidal thoughts, and had run-ins with the cops. She was sent to a facility designed for kids with challenging backgrounds. There, she spent 6 days and was prescribed Paxil for what was diagnosed as mild depression. Here's where the story takes a real twist. Kristen found some stability after being sent from sunny Oxford, Florida, to live with her grandparents in Chester, South Carolina. She had a mother who had deserted her twice and a father she described as abusive. Her doctor in Chester didn't have any Paxil samples, so he gave her Zoloft instead. But switching them out like that is not the best idea. Kristen started feeling off almost immediately, with her sister even describing her as manic. She experienced a weird burning sensation all over her body that needed pain medication to control. The doctor's solution? Increase the Zoloft dosage from 25 to 50 milligrams per day. Zoloft has a laundry list of potential side effects in kids, including aggravated depression, abnormal dreams, and even hallucinations. So, it was like adding fuel to an already raging fire. On November 28, 2001, Kristen's day was already spiraling out of control. She got into fights on the school bus, choked another student, and disrupted a piano player at her church. That night, after her grandfather disciplined her with paddling for trying to leave her room, she did something unimaginable. She went into her grandparents' bedroom and used their shotgun, the one they had taught her how to use, to end their lives. It didn't stop there. She set the house on fire using a candle and some paper, grabbed the car keys, took her grandparents' firearms, her dog, and a measly $33 and hit the road. However, she didn't get far. 2 counties away, she was caught after getting stuck. Initially, Kristen spun a tale about being kidnapped by a large black male who had killed her grandparents and set the house on fire. However, she eventually confessed, chillingly stating that her grandparents deserved what they got. Remember, this happened just 2 days after her Zoloft dosage was doubled. Kristen's trial commenced on January 31st, 2005, 3 years after the shocking crime. The question arose, was this a case of murder or some lesser form of homicide? As the trial went on, the narrative honed in on the Zoloft factor. Prosecutors aimed to show that Kristen was fully aware of the gravity of her actions, citing her premeditated plans to escape the fire she set and her calculated getaway. Fast forward to February 15, 2005, Kristen was found guilty and sentenced to 30 years. However, in December 2010, she struck a plea deal, pleading guilty to voluntary manslaughter with a new sentence of 25 years, including time already served. While imprisoned, Pittman transitioned and legally changed her name to Kristen Avery. On February 12, 1993, 2 boys named Robert Thompson and John Venables kidnapped James Patrick Bulger, a boy from Kirkby, Merseyside, England. They tortured and killed him. That day, Thompson and Venables were observed stealing various items, such as candy, batteries, a troll figurine, and a blue Humbrol craft paint container. Later that afternoon, James Bulger and his mother, Denise, visited the New Strand Shopping Center in Kirkby. While in the A.R. Tim's meat market on the mall's ground level, around 3:40 p.m., Denise momentarily released her son's hand to complete her purchase and discovered that he was no longer beside her. Thompson and Venables had approached James, grabbed his hand, and led him away from the shopping area. The boys assaulted Bulger and eventually killed him. Bulger's body was found 2 days later. On November 24, 1993, John Venables and Robert Thompson were both convicted for the kidnapping and killing of James Bulger. Following 8 years of imprisonment for their roles in the tragic case, the perpetrators were set free under a life license. To shield them from potential retaliatory violence, they were given new identities. Ricky and Danny Preddy. In a heart-wrenching incident that shook the nation on November 27, 2000, Damilola Taylor, a schoolboy from Nigeria, fell victim to a fatal attack in the heart of London. This tragic story became one of the United Kingdom's most widely publicized murders. To walk home that day, Damilola Taylor left Peckham Library in southeast London at 4:51 p.m. He was seen on CCTV as he walked away. Upon reaching the North Peckham estate, he sustained a wound to his left thigh. He staggered to a stairwell, fell, and within about 30 minutes, bled nearly to death. While being transported to the hospital in an ambulance, he was still alive. Danny and Ricky Preddy, who belonged to the Young Peckham Boys gang, terrorized South London's neighborhoods. Danny Preddy should have been under a 24-hour curfew at a social service home during Damilola's murder because he was rarely out of monitoring or custody. Just 4 weeks after the murder, he received a supervision order for 2 incidents of racially aggravated assault and an assault with intent to rob, which he disobeyed. Ricky Preddy had a history of thievery and violence and was expected to be in charge when the schoolboy was killed. It took 6 years and 3 trials after Damilola's death to find and convict his killers. Danny Preddy walked free in 2011, receiving an early release after serving just 5 of his 8-year sentence. His brother Ricky got out even earlier, on parole, just 4 years into his 8-year term. But it doesn't end there. Ricky was back behind bars in March 2011 for breaching his license conditions. While he was in there, he got into a fight with another inmate. Despite this, a parole board decided to let him out on January 25th, 2012. Just over 2 weeks later, Ricky Preddy was back in jail again for breaking parole by hanging out in places he wasn't supposed to and visiting old gang friends. In November 2019, Ricky cruised through Wembley when the cops signaled him to pull over. What did he do? He reversed into the police car, injuring a female officer, and then sped off. They eventually caught him, and now he's facing another 4 years in prison, along with a 12-year driving ban once he's out. Fairweather James was another sadistic teen criminal who fantasized about becoming a famous serial killer. He was sentenced to 27 years in prison for stabbing 2 people, both of whom lost their lives. The first victim, James Atfield, who had a brain injury, was attacked by Fairweather in Colchester, Essex, on March 24, 2014. 3 months later, he struck again, this time targeting Nahid Al-Manea, a 31-year-old Saudi student at the University of Essex. James was apprehended while planning a third assault in May 2015. He confessed to both killings and pled guilty. He was very young when he committed the crimes and attended Colchester Academy. James had been a victim of bullying for many years and struggled in school, partly due to dyslexia and autism. He explained his actions without displaying any signs of remorse. He attempted to appeal his sentence on the grounds of his age and mental functions, but his appeal was ultimately rejected. Terrence Andrus, a man from Texas, was found guilty of murder and sentenced to death in 2008 at the age of 20. He killed Avelino Diaz and bystander Kim Phuong Vubui during an unsuccessful carjacking while under the influence of PCP-laced marijuana. His case eventually reached the U.S. Supreme Court, which determined that he had received unconstitutionally ineffective legal counsel at his murder trial. The court's decision was based on compelling mitigating evidence in the habeas record, none of which his counsel had presented to the jury. The court also found his counsel ineffective for several specific failures to investigate and rebut the state's case in aggravation. However, despite the Supreme Court's decision, a Texas court defied the opinion and reinstated Terrence's death sentence. The Texas court concluded that Terrence failed to establish bias and denied habeas relief, disagreeing with and rejecting the determinations underlying the Supreme Court's finding that Terrence's counsel had provided deficient performance. On September 19, 2021, Robert Shepard fatally shot Frank Q. Jackson in Ohio. Shepard might not have realized the severity of his actions, or that Jackson was the mayor of Cleveland. When Judgment Day comes, the criminal's facade of being a Robin Hood fades, leaving only fear behind.
Thank you, Your Honor, for that opinion. I did file a sentencing memorandum with the court with respect to this matter. I assume you have received it. I also gave that to defense counsel. With respect to merger, all of the offenses for which the defendant was found guilty in the state of Ohio allege that the defendant be sentenced in this case under count 1, aggravated murder, together with the 3-year firearms investigation. Basically, there are 4 potential sentences that this court could impose today. Now, I would anticipate certainly the defense may argue it's not the most serious form of the offense, or that this defendant's role was less serious because he was the setup person. But as the law says, under complicity, he is as equally responsible as he pulled that trigger, and that is the verdict that this jury gave us. I ask that you consider that, Judge, and consider that but for that relationship that this defendant had with Frank, that really drove him literally to that spot where he ultimately lost his life.
Doesn't the fact that they had a relationship make it even worse?
I think so, Your Honor. And also, I know that that's a sentiment that the Jackson family feels. They've asked me to read something on their behalf. One moment. They've asked me to relay that portion, that information. They do know that this defendant knew Frank and knew the victim, and that helped facilitate this offense. The media's scrutiny on this case has been difficult for this family. They have chosen not to address the court today. I hope that this court understands what impact this has had on the Jackson family throughout the pendency of this case. After Frank's his mother passed away, they were dealing with a lot of loss. They are still feeling that loss today. They were here for every step of this trial, and they're asking this court to impose a sentence that is adequate for this defendant's actions and to show justice for Frank Hugh Jackson. Thank you. I'd also asked Judge, I did include in my sentencing memorandum as well, the defendant's criminal history and why that should factor into a sentence in this case that's more than minimum. He has a juvenile history that goes back to 2005 that includes assault and offenses, and he has an adult history that includes attempted burglary and also offenses. And while they were low-level felonies on the adult side, he has previously been to prison. And clearly that didn't change his involvement or later involvement in future criminal activity.
Deciding someone's fate is a serious responsibility. The judge carefully examines every detail before deciding, knowing their judgment shapes lives.
His most recent cases are from 2018, failing to comply with the order of the police officer. He has another case, felony free possession, having a weapon while under disability, carrying a concealed weapon, and then he has a series of attempted aggravated burglaries, and then additionally another attempted carrying a concealed weapon, not including the juvenile history. I also want you to know that I reviewed rather carefully the defendant's institutional records, his prison records, which were, from the court's perspective, disturbing, because the defendant has a rather aggressive history at ODRC, which is outlined in my report. I also reviewed the defendant's mental health records, for which he is here on my docket specifically as a mental health court judge. And I want you to know, Mr. Jordan, that I did take into consideration and mitigation his mental health. And I did review all of the reports that I have related to that. There are some challenges to his multiple diagnoses. So it's not just one diagnosis, but many that are troubling for Mr. Shepard, which makes it, frankly, probably the reason why it's so difficult. He has such a challenging time in the institution and has caught so many infractions. But he is listed as being Carl's son, and he's currently listed with that category of delineation in the prison institution and in our jail. So that is something to be concerned about for sure. Ms. Carpet, did you want to add anything else at this time? No. Ms. Carpet, there was no information regarding this case, is that correct?
That is correct, Your Honor.
So no additional information to glean with regards to other than, of course, what Mr. Shepard's goal could have been in this case in solving perhaps the rest of those circumstances.
That is correct, Your Honor. This is still an ongoing investigation. Human homicide is not put this aside, but certainly in terms of identifying that, based on the jury's determination in this case, it's apparent the defendant knew who they were, knew who the was, knew who the driver of the Chrysler was. Knows who took him from that scene as well. And silence is golden. Here we are, and again, as I indicated, this may be the only person who's held accountable under those circumstances.
Can I ask you just one more question? Do you know how Robert Shepard and the victim knew each other?
They've had a long-term relationship. He also knew other members of the Jackson family as well.
So the Shepard family and the Jackson family know each other?
I can't say the family, I can say the defendant also knew, for example, Frank's sister.
And then the emphasis that we had on the Lonnie Burton part, if you recall the video testimony where we observed what is a person wearing similar clothing to Frank Hugh Jackson walking through the park, but happens to be a 12-year-old boy who is then, as Frank is going into a different direction, they cross paths. What happened to that boy? Is he okay?
He's still alive. He did survive his and that no one has been apprehended or prosecuted in relation to his as of yet.
So he just happened to be the unfortunate person wearing almost an identical outfit to
crazy huge accident that night. He's in the wrong place at the wrong time. There are two other individuals not captured on video. It also received relating to that shooting. Thank you. Anything else on behalf of the state of the Sun? Mayor. Mr. Jordan, I know that you have family members that they want to address the court this time.
Judge, actually, I've spoken with the family and they do not wish to make any comments at this time.
What would you like to say?
Judge, at this time, I would defer to the court. I would ask the court to consider minimum sentence in this particular case. My client will be appealing this conviction. We would ask that the court appoint him counsel as he is indigent at this time for the appeal. At this time, that's all we have to say.
Very well.
After the jury delivered the verdict, the defendant's family was shocked, but the court remained unchanged.
Mr. Shepard, you have been found guilty on all counts, on all charges, and on all specifications. Juror number 1, is this your verdict? Juror number 2, juror number 3, juror number 4, juror number 5, juror number 6, juror number 7, juror number 8, juror number 9, juror number 10, juror number 11, and juror number 12. Very well. Thank you, ladies and gentlemen. Lawyers, can I see you at sidebar just briefly, please? Joe, let's excuse the jury right now. Ladies and gentlemen, all rise, please. Jurors. One second, Carla. All right, ladies and gentlemen. So we're going to set sentencing for perhaps next week sometime.
The past always follows a person. Prior offenses cast a long shadow on the present, and the judge took this into account when delivering the sentence in this case.
And he was just recently released from prison as of like last year, or within the last year and a half. When did you get out of prison? 2019 or 2020?
2020.
Okay.
In March.
So released on the failure to comply with the order of signal of police officer, released on the cases, and then ultimately the defendant has had criminal history from the time that he was a juvenile. He spent many years in different juvenile institutions and has essentially been incarcerated for most of this time. So have you ever been given a term of probation, Mr. Shepard? No. Also, I want to note for the record that I did consider the defendant's competency report and his mental health history. I did review your sentencing memorandum, Ms. Carcott. I want to note for the record that the defendant has multiple diagnoses which brought him to the mental health docket. But the most significant of those diagnoses is regarding a personality disorder for which he has. The defendant has multiple different diagnosed disorders that are very troubling to the court, and I'm going to incorporate those records into my sentencing memorandum or my sentencing entry. So those will become court exhibits for future review. To begin with, in watching and observing this trial, I was very sad for the state of our city. To know that Bonnie Burton Park, a place where there were children playing, walking through the park, knowing that he was through mistaken identity under the circumstances here was horrifying. Watching the come out in his child in the parkway was unbelievable. Our city is a disaster when it comes to violence, and there has to be something so dramatic that happens to stop it. People don't even want to walk on the east side of Cleveland. It's frightening. But also,
the retribution of families, other families, is horrible. Not cooperating with the police, not solving anything. It's just going to lead back to this courtroom and all the courtrooms here in this building over and over again until it stops with people's families. It's a tragedy that we are here today. The court, having considered all the required factors under 29, 11, 12, and 13, at this time sentences the defendant to 3 years on the underlying specification and 30 years life with the possibility of parole and 30 years on the aggravated for a total of life with the possibility of parole in 33 years. I'm going to note that the state elects on count 1 and the 3-year specification. All the other counts merge into count 1. I am going to give you credit for 384 days for which you served. You have 30 days in which to perfect an appeal on this case. I am going to appoint Attorney Pagano as your appellate counsel, and I am going to order a transfer to the state expense. I am going to, at this time, order that you be remanded and transported. I am going to waive your fine, however, I am going to impose court costs in this case. With that being said, if there's anything to be adjusted as it relates to indigency, Mr. Pagano, you can file that with the court. You are ordered remanded and transported at this time.
This case involves two individuals who committed an act so heinous that it makes you think, for once, that some criminals should be executed on the spot.
All I can think about is my son want his mommy. Where's my mommy? He's screaming for his mommy for the little seconds he had. My son.
On December 11th, 2021, in Euclid, Dwayne Trarin Jackson and Leroy Anthony Billups fatally shot Marco Toller. This incident shocked the entire community. The pain of losing a family member lingered in the relatives' memories, and from the depths of their souls, Marco's family expressed their profound grief and sorrow.
Good afternoon, Judge. My name is Dylann Pruitt, Jillene Pruitt. And today is a very tough day for everyone in here. You know, even you as a judge, to be in a position to make a judgment that alters the emotions of a mom, the emotions of another mom, and how the rest of her son's life will continue. Marco was only 13, doing what he was supposed to be doing, going to visit a close friend, you know, riding his bike. And like his grandmother said, there are some things he cannot enjoy because he's no longer here. And that time was taken away from him. I am also a woman of faith and know that and agree that there's a lot of loss here today. It's not pleasing, you know, to even be sitting on the other side of another young male who also still have so much life ahead of him. And I do pray that however life happens for him, that is fair, he rehabilitates and understand, you know, that although he will get whatever time he gets today, he gets to get that time. We don't get time with Marco. That time is gone. It stopped for us. And, you know, at the choices of someone else, for whatever reason they chose to make them choices, you know, on that day, for us, we'll forever be mourning. You know, we'll forever not know what man he would have become. Just, it's over. That part is over. So, I mean, and he was 13, he meant a lot to so many people. He impacted so many lives. There are so many people that I've met since his life was taken away that they were like, wow, I did not know that was your your godson. Like, I've been knowing him since he was 8. He come over and cut my grass or just call and see how I was doing. Even as a child, just very compassionate. And I'm going to read something that his best friend gave to his mom this morning. You know, just a way to show also further how much he meant to his peers, those that loved him. Marco was like my baby brother. I met Marco when he was in the 1st grade and I was in the 2nd grade. It was 3 of us, Marco, Deanna, and I. We were like 3 musketeers. That's what Deanna's mom called us. We were inseparable. We were family. Nothing else different. Although Marco was the 2nd oldest, he always acted like he was my older brother. I love that about him. Unfortunately, we lost Marco to violence, December 11th, 2021. This took me and Deanna by surprise, and we have never imagined losing someone we love so dearly, someone we never thought we would lose. Marco was a sweet, loving young man. That's how the man described him at the balloon release. I know that my baby brother was sweet. He told everything how it was. He was bold. He was truthful. He was trusting. My baby brother was my hero. He was someone I know I could always count on if I needed anything. If anybody really knew him, they knew that he didn't play about his family. He came up with something great he called Operation Feed the Family. We all knew Marco was a good kid and could do anything if he wanted. He just had to put his all into it. And Deanna and I were his everything. We were his hearts. We all looked out for each other, and we had a bond that could never be broken. Now it was up to me to make sure that my sister is all right all the time and to keep that smile on her face. I promised Marco that I would never forget him, and I would always be there for his mother and his sisters. Now his sister is having a baby, and I can't wait to tell her. I can't wait to tell her all about her Uncle Marco. So he would never meet that niece because he's not here to. And you know just the case, and he's another, young kid. But for everyone who does not know him, he really, to be so young, had so much love from people in the neighborhood. And just like a quick story for me that I was thinking about today that always makes me laugh about him is, I was going to pick him up one day, and he told me, he said, "God, Mommy, if I'm not at home, I'll be up the street over my friend's house. And we'll be outside on the porch because that's where we always hang out, on the porch." So I'm imagining when I get to him to meet his friend, someone his age. And he told me also, like, yeah, we're going to talk about coming up with a plan for our lemonade stand. And when I get there, sure enough, Marco was not at home. He was down the street at this friend's house. So the person, he said, "God, Mom, I want you to meet my friend." I'm like, okay, go in the house and get him. He's like, "No, my friend right here." It was a 62-year-old man that lived up the street from them, who he went and helped sell hot tamales and cut his grass and learned all kind of great just entrepreneur skills from. And I did not imagine that I was going there to meet someone who could be his grandfather. But, that just goes to show I'm so grateful on one hand that God gave us those years and so many other people that opportunity to meet such a fashionable and, remarkable young man. But it's so many more remarkable memories that we no longer have. So I ask that you just, take all things today into consideration, and that God be with you in making your choice.
Is there any reason for a mother to overcome the pain of losing her child when someone takes her child away?
Anita Deal, ANITA DEAL. I am Marco Craig Lamar Toller's mother. Where do I start? Oh, Jesus. Oh, Your Honor, December 11, 2021, I just came home from work. I talked to my son that morning. He was coming home the next day. I get a phone call from his counselor. I'm on my way to you. Why? Year-old boy, Marco Craig Lamar Toller. I screamed. I yelled. Morticia, let's go. I gotta get to see me. I gotta find my child. Something ain't right. I called where he was supposed to be at. With my son. I don't know. I get to see me. And no other police officer in Euclid. My kids, they was at every event. I see yellow tape. I run. He full of tears. My son, let me get to my son. He didn't let me see my baby. I fell down. I couldn't breathe. My daughter grabbed me. The officer grabbed me. I'm sorry. I stayed on the ground for hours. My baby couldn't move. I didn't want to go. All I can think about, my son want his mommy. Where's my mommy? He's screaming for his mommy for the little seconds he had. My son, in a matter of moments, you heard it. Years old, you listen. They tried to make my son out to be somebody different. He visited his best friend. No, he didn't belong there. Who can keep best friends away from each other? They did everything together. You would think I raised her. You just thought I birthed her. She's been around the world with me. North Carolina, South Carolina, everywhere. Wow, Florida, why would her mother not let her go with me? Why wouldn't I let my son go over there? Who cares about a court order? They're kids. They're kids. They were playing in the house because of the rain and got trespassing. They were kids. If my son was here today, he would play so much music for you. My son been since he was 9. He called himself a little demon. Operation Define Me. He made that. He wanted to support his family. He wanted to make his mama proud. I don't care what my son did in this world. He wanted his mama to be proud of him. Proud of him. I have not slept a night peacefully because my son not running through my house. I've been told to go my son up. Why? Why would you form them words on your mouth to tell me to dig my son up? And you want me to have sympathy for your child to do bare minimum? And I'd never give my child, I'd never see my son. Anybody that know Marco, no. He run through the house and say, I love you. If Marco knew you, Your Honor, I love you. My son told everybody in this world he loved them. He didn't just show it, he expressed expressed it. He ran up to you. Godmommy, I love you. Cousin, I love you. Now, can I have some money? But that was Marco. I worked for it. What you got me to do?
The judge delivered a fair sentence after considering all the facts in Marco Toller's case.
My sentence will reflect that. I have considered Mr. Billups' age as required by law, and that age will have the benefit of an opportunity for parole statutorily that the DRC must consider after 25 years, regardless of what the sentence is in my case. But I will impose the following sentence. In count 3, life in prison. The eligibility of parole after 15 years, the 3-year specification must be served prior to and consecutive to that 15 years. Counts 4 and 5 and the specifications are allied offenses of count 3, and the discharge of on or near a prohibited premises in count 7, I'm also going to find merge, and those specifications. So no conviction will be entered on count 4, 5, or count 7. On count 6, I find that it is not an allied offense. Improper discharging of at or into a habitation or school, and the 1 and 3 year specification will be imposed. The 3-year specification will be consecutive to the 3-year specification in count 3. I'm imposing on count 6, 8 years in the Lorraine Correctional Institution as well. In count 9, tampering with evidence. It's a felony of the 3rd degree. 3 years in Lorraine Correctional Institution as well. That tampering with evidence was a clear indication of a lack of remorse or responsibility for what occurred. And I've taken that into consideration. And therefore also, consecutive sentences are appropriate in this matter, despite the statute, in addition to the 3-year mandatory consecutive nature of the 3-year specifications. I am going to impose consecutive sentences, finding that it is necessary to protect our public and punish this offender. It's not disproportionate to what occurred in this case. The ending of the time the family has with a 15-year-old child, family member. All the positive things that a 15-year-old would have done in our community, lost. Also, specifically finding the harm is so great or unusual, a single term does not adequately reflect the seriousness of the conduct. So that is a total of 32 years before the possibility of parole. As I said, statutorily, you will be eligible for the parole to consider release by the statute 2967.132 after 25 years of incarceration. Post-release control is part of the sentences on the felony of the 2nd degree and felony of the 3rd degree. Those are mandatory minimum of 18 months up to a maximum of 3 years. The F3 is discretionary up to 2 years. If you commit a crime on parole or post-release control, you can be returned to the prison up to 9 months, and you could have a consecutive prison term imposed for the time remaining on post-release control, or 12 months, whichever is greater, and you're facing life if you are eventually paroled and you violate your parole. You will serve your life sentence. Also, pursuant to the information provided from Ms. Deal, I'm ordering $3,125 restitution that you're jointly and severally responsible for with your co-defendant, imposing also, as required by law, a Class 2 driver's license suspension since this crime occurred with the involvement of a motor vehicle. and I'm imposing a Class 2 suspension for life. You can apply for driving privileges if you're ever paroled. Also, you are required to pay your court costs, and for community work service may also be required. I'll grant your jail time credit. Docket indicates 499 days, including juvenile court detention home. Is that correct, Mr. Leonardo?
That's correct, Your Honor.
499 days, jail time credit. You have the right to appeal your sentences and convictions. If you're indigent, I can appoint an attorney and provide a transcript at state's expense. I have received the affidavit.
This Karen sounds kind of biased.
I don't think the mother should pay child support to the father.
I'll get to you in just a moment.
Hello, great evening, sunshine.
Okay, all of that extra.
Full
You know,
story.
although I love the Vogue, we don't need it right now, okay?
I'm so sorry.
This woman is asking for more child support money for a child who doesn't even live with her. Her reasoning is confusing, even the judge.
Years. Are you paying child support?
I'm paying child support.
Okay, so that's why you're here. You're trying to get off child support. But for now, how does your son
10?
lives with you? You take care of his expenses and everything like that?
Yes, ma'am.
You mind if I move over to her? Because I need to make sense of why she filed this in court for an increase.
I do buy things for my son, and it's
So does other parents. So why are you here?
well, I have a business to run, and I need his help in order to buy these things for our son.
Your son lives with him.
Now he does.
Now, as in 3 years ago?
3 years.
That's not now. So you want an increase in child support
Yes.
to do what exactly?
To help my son, to buy things for my son.
You came here to get an increase in child support that you can pay for your catering business. That doesn't sound right to you?
No, ma'am.
Why doesn't that sound right?
I have to buy things for my son, and I can't do it alone.
He buys things for your son.
Well, I need to do that too.
You make $400,000 a year, ma'am.
Well, I have employees and things to pay.
What do you think he should do? Pay you more
Yes.
while your son lives with him?
Well, I still see my son.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.